I want to echo something that's been mentioned once or twice this morning, but emphasize it again. I think it's important that we do this as senators, because I believe that among the founding generation, the founding fathers, there was no understanding that was more ubiquitous than the idea that what we were creating at the national level was not an all-purpose national government possessing general police powers, but a limited purpose federal government. And I think one of our jobs as senators is to make sure that regardless of what the courts say that we can get away with in court, regardless of how broadly we may exercise our power without judicial interference, that we take a second look and say, separate and apart from what the court says we can do, should we be doing this? Is this consistent with our role as legislators operating within a government with decidedly limited powers? I also like the quote from Justice Jackson that was pulled out a few minutes ago, I think by Mr. Kroger, to the effect that certain decisions are wisely left for Congress. The courts lack the authority to be a sort of roving commission on all things constitutional. We have to make a number of these decisions on our own, regardless of whether the courts are going to do them for us. I wanted to ask a few questions of Mr. Dellinger, if that's okay, Professor. Do you agree, first of all, with James Madison's assessment that Mr. Cornyn quoted a few minutes ago, that while the powers of the federal government are few and defined, those that are left to the states are numerous and indefinite?
I do agree, and I think Senator Cornyn correctly cites Federalist 45 for that proposition. And as I said, Senator Lee, within the area of Congress's authority to regulate national commerce, what has grown is the interdependency of national commerce, not our understanding of the Constitution.
Sure. It has grown, but they had interstate commerce then. They were interconnected. In fact, that was the whole reason why we needed to be a union in the first place, right?
Correct.
We couldn't survive. So they understood this interconnectedness. This is not new. It's been facilitated by jet airplanes and by the internet, but...
That's right. But if you got sick in North Carolina in 1787, it had no effect in Utah.
Well, Utah didn't exist. It was part of Mexico. Still a lovely place, but
it had no effect in Pennsylvania, if I may remark.
Okay. But they were interconnected, so perhaps the changes that we've had have been changes of degree. Perhaps we're more interdependent then than we were now. But you would still agree that it's still accurate to say the powers of the federal government are few and defined, whereas those reserved to the states are numerous and indefinite.
Yes.
And yet, if this law is upheld, if this law is within Congress's limited power to regulate commerce among the states, notice it didn't say commerce. It says commerce among the several states and with foreign nations. If this is within Congress's power, wouldn't it also be within Congress's power to tell every American, including you and me and everyone in this room, that we must eat 4 servings of green leafy vegetables each day?
No.
Why is that? What's the distinction?
The distinction is that a regulation of commerce, to be constitutional, has to be a permissible regulation of commerce. And something which intrudes into the area of personal autonomy doesn't meet that standard.
Like, say, deciding where to go to the doctor and how to pay for it. I mean, I'm trying to understand the difference between the personal autonomy at issue there and that presented by this law.
Well, the case about broccoli is a case that is covered both by Lopez and Morrison. That is, you're regulating a local, non-economic matter, what you eat and whether you exercise. And it is also governed as well. It is doubly unconstitutional because it's governed as well by the principle in cases like Glucksberg and Vacco and Cruzan that say that an individual has a right to refuse unwanted medical treatment. You have a constitutional right to refuse, and I think.
And please understand, Professor, I'm talking about Commerce Clause here. I'm not talking about due process.
I understand that.
Let's keep our discussion limited to Commerce Clause.
And I think if you talk about whether Congress could require people to buy other products, what would be Congress's legitimate reason for doing so? I think there would be many constitutional objections.
Oh, I can come up with one right now. I mean, look, if we are going to make sure that everybody's got health insurance and that the government's going to pick up the slack behind, then Congress could assemble a panel of experts, let's say your functional equivalents from the dietary council industry, who would come and tell us that if you eat 4 servings of green leafy vegetables every single day, you're 50% less likely to suffer from heart disease, cancer, stroke, or a whole host of other ailments. That's going to cost the government less money. So there is it's a pretty tight nexus there.
Yes, but as the court said in Gonzalez versus Rage, that's a Morrison and Lopez problem of dealing with non-economic matters. And the court said in Gonzalez, where the act under review is a statute that directly regulates economic commercial activity, our opinion in Morrison casts no doubt on its constitutionality. This is a direct regulation of a commercial activity, not something that merely affects a commercial activity.
Okay, let's change the hypothetical just slightly then. Instead of saying you must eat them, it would say you must take the first $200 out of each month's earnings and purchase the equivalent of 4 servings of green leafy vegetables to eat per day. This all of a sudden is economic activity. This is not Lopez, where we're talking about bare, non-commercial, intrastate possession of a firearm within a school zone, or about Morrison, where you're talking about non-economic intrastate acts of violence.
Okay, it seems to me that there are 2 responses to the argument that upholding this would stand for the proposition that Congress can force people to buy anything. The first is that this is a requirement that you make provision to buy something which you cannot ever be assured you will not use and cannot be assured you won't transfer the cost to others. So I think it's distinguishable. But secondly, the very form of that argument was used to attack the minimum wage and Social Security.
Well, Social Security was upheld as a valid exercise of the spending power.
Wage, your question to me, if the issue were the constitutionality of the minimum wage law and it were 1937, you would be asking me, is it a regulation of commerce for Congress to have a minimum wage of $5,000 an hour? And that has never been a legitimate. Is it a regulation of commerce to say that if you buy 1 car, you have to buy 3 cars? That form of argument, I think, was used against Social Security, used against Medicare, and Congress has, in fact, never abused that. It's never set the retirement age at 25, as the opponents of the Social Security Act said would be possible if you upheld a retirement plan for people over 65. So the very form of the argument, I think, deflects attention from what is basically a completely unremarkable regulation of an important national market.